So next, as for next type and next type of the defense is the intoxication. Like the defense of the mental incapacity, intoxication may be considered to exclude the responsibility of the accused in the sense of excuse, while mental disease or defect is universally recognized as an affirmative defense. Intoxication is recognized only in a limited way. Article 31, paragraph 1, clause B of the ICC Statute states that individual responsibility to preclude when the person is in a state of intoxication that destroys the person's capacity to appreciate the unlawfulness or nature of his or her conduct, or capacity to control his or her conduct to conform to the requirement of the law. The defense of intoxication seeks to excuse of the accused from responsibility on the basis of the exceptional circumstances that form the context of their intent to commit a crime, robbing them of exercise of the rationality in controlling their instincts or resisting the influence of the others. The application of the defense intoxication in Article 31, paragraph 1, clause B is limited by the adoption of the following principle. Unless the person has become voluntarily intoxicated under such circumstances that the person knew or disregarded the risk that as a result of the intoxication he or she was likely to engage in a conduct constituting a crime within the jurisdiction of the court. The primary focus of the text of the article is involuntary intoxication, that is to say, when a person unwillingly becomes intoxicated owing to inadvertent consumption of the drugs or alcohol. Voluntary intoxication is only a defense when a person did not realize that he or she might engage in a conduct prohibited by the statute and was not at fault of disregarding such risk. Taking drink or drugs to gain Dutch courage will not provide the basis for a defense under this provision, as the person will know of at least the risk that he or she will commit the offense. So, regarding the intoxication, there's a destruction of the capacity. The intoxication must have destroyed the person's capacity to understand the nature or unlawfulness of the conduct, or ability to confirm the law dictates. Impairment even of a substantial nature is insufficient to exclude a person liability. On the language of Article 31, paragraph 1, clause B, it appears that the person must be incapable of understanding or controlling his or her conduct. It does not appear sufficient that the person simply did not do owing to the intoxication, although it is uncertain if this was the intention of the drafters. It is not clear precisely how specific the risk of the conduct has to be exclude the defense. Students, next type of the defense, that is the defense of the self or others and the certain properties. So self-defense is a fundamental concept in the most domestic legal system, and probably which we also called in our domestic law, that is a private defense, so probably constitute a general principle of the international law. In its essence, it is the simple form of the justification, despite the fact that the elements of the crime were undoubtedly committed. The conduct of the accused was not wrongful because their motive was lawful, and the crime committed was arguably the lesser of two evils. Therefore, the application of the doctrine in context of the genocide, armed conflict, or widespread or systematic attack against the civilian population is plainly problematic. In Article 31, paragraph 1, class C of the ICC statute states that individual's responsibility is precluded when the person acts reasonably to defend himself or herself or another person, or in the case of war crimes, property which is essential for the survival of the persons or another persons, or property which is essential for accomplishing a military mission against an imminent and unlawful use of the force. in a manner proportionate to the degree or danger to the persons or the other person or property protected. The fact that the persons was involved in a defensive operation conducted by force shall not in itself constitute a ground for excluding criminal responsibility under this paragraph. The self-defense doctrine is known to the ad hoc tribunal but has never been successfully pleaded. The leading case in point is in effect heavily influenced by the provision in the ICC Statute. It interprets Article 31, Paragraph 1, Clause C of the ICC Statute to impose a two-part test. First part A, the act must be in response to an imminent and unlawful use of force against an attack on a protected person or property. B, the second part, the act of the defense must be proportionate to the degree of the danger. It goes on to stress the fact that the wider context and strategic objective of the military operation is relevant. The involvement of a person in a defensive operation does not in itself constitute a ground for excluding criminal responsibility. It is therefore clear that any argument raising self-defense must be assessed on its own facts and in the specific circumstances relating in each charge. In this context, it is important not to confuse a defense under Article 31, Paragraph 3, Clause C of the ICC Statute with the principle in general international law of the self-defense pursuant to Article 51 of the UN Charter. These provisions deal separately with individuals and state actions at large. In the absence of any ICC case law yet on the point, it is difficult to predict how the ICC will interpret the requirements of the test for the self-defense. Until such time as a decision is rendered in the contrary, it is appropriate to adopt a conscious approach along the following lines. The element of the force when used in order to defense on life, others' life or property, force must be understood broadly, encompassing physical coercion and psychological threats. It must be imminent, and that is the immediately antecedent, presently exercised or still enduring, which means that a preemptive strike against a feared attack is excluded as a retaliation for a successful attack. The use of force is unlawful if not legally justified. Given this broad definition, only the danger implied by the use of force can restrict the scope of the application of the self-defense. Certainly, danger must imply a serious risk for the life or physical integrity of a person. The extension of a self-defense to exclude the protection of the certain property is novel and has proved somewhat controversial, quite apart from the property essential for the survival of the person. Most importantly, it must be noted that the Professor Embus also suggests there is a third limb of the test not contained the subparagraph C, but derived from the general principle of law according to Article 31, paragraph 3, in connection with the Article 21, paragraph 1, clause C of the ICC Statute. This third element is subjective element of the self-defense, and it requires that the defender must at least know about the attack. It is controversial whether he or she must also be motivational by this knowledge. So clearly, significant aspect of the manner in which self-defense will be applied before the ICC, and given the approach adopted in Kartik case, possibly also before the ad hoc tribunal, remains ambiguous. The trial chamber in Kartik and Sarkis case, the accepted that the customary law recognized self-defense, an uncontroversial finding made more contentious by the fact that the chamber asserted that the formulation found in ICC Statute represented customary law Article 31, paragraph 1, clause C. which provides for an acquittal when the person acts reasonably to defend himself or herself or another person, or in the case of war crimes property, which is essential for the survival. So uh, the next topic in the defenses is the dues and necessity. This is the last topic before we are moving towards the our final topic of this course and today's lecture after this session. And this topic, dues as necessity in Article 31, Clause 1, Clause D of the ICC Statute states that individual responsibility to preclude when the conduct which is alleged to constitute a crime within the jurisdiction of the court has been caused by a duress resulting from a threat of the imminent death or of continuing or imminent serious bodily harm against that person or another person, and the person acts necessarily and reasonably to avoid this threat, provided that the person does not intend to cause a greater harm than the one sought to be avoided. Such a threat may either be made by other persons or constituted by other circumstances beyond that person's control. Despite the fact that the expressing wording of this provision refers to only dues, it is reasonably well established that the related defense of the necessities also including dues refers to a situation deliberately caused by other people. Necessity refers to a requirement for action in response to the circumstances which may or may not be attributed to an intentional conduct of others. Both concepts unite in the idea that the violation of the accused is overwhelmed by an external force mandating a particular course of the conduct. Dues and necessity may be considered to be particularly important issues to the context of the international criminal law, where crimes frequently occurs within the framework of a web of the personal relationship. At the same time, the very relevance of the concept is a source of tension. The codification of the dues and necessity in the ICC Statute may be welcome development in one of the earliest decision in the Predominant case. The judges of the ISTY appeals chamber gave the long and careful consideration to the defense of the dues. The case of the prosecutor versus Drazen Idomovic, case number IT 96-22. According to the indictment in July 95, has loads of Bosnian Muslim civilian men from the Srebrenica between age 17 to 60 years were transferred to, among other places, a collective farm near Pilika in the Zvornik municipality. On the arrival at the farm, the Bosnian Muslims were removed from each bus in group of about 10 and escorted by the members of the 10th Sabotage Detachment of the Bosnian Serb Army to a field adjacent to the farm buildings, where they were summarily executed. Drazen Erdomovic, born 25th November 1971, was a soldier in the 10th Sabotage Detachment of the Bosnian Serb Army, and as a member of the firing squad of that unit, he participated in these executions. He was charged with the murder as a crime against the humanity, or alternatively murder as a violation of the laws of custom of the war. May 96, Adomovic pleaded guilty to the charge of the murder as a crime against humanity by participating in the execution of the unarmed civilian Muslims in the Srebrenica in 1995. He admitted personally killing approximately 17 civilians in response to being expressly threatened that if he disobeyed the order to kill, he would be executed himself. The trial chamber accepted Adomovic's guilty plea and dismissed the alternative charge of the murder as violation of the laws, a custom of the war. November 1996, the trial chamber sentenced Adomovic to 10 years imprisonment. The trial chamber did not accept the plea of extreme necessity put forward by the accused because the defense produced no corroborative evidence. So this case this is the very relevant case regarding the when there is a necessity of committing any offense. Is in this case, the accused took the defense that he was in a necessity, he was in a dure, and he was in a fear that if he did not obey the commands and orders of the superior, so alternatively he will be killed. So he in that duress and in necessity he killed the Bosnian Muslims. So as indicated in the above summary of the case, ISTY appeals chamber concluded that although the defense exists in international law, it may not be relied upon as a defense to crime which involves the taking of the human life. For at least two of the majority, this conclusion seemed to be reached at least in a part on policy grounds. Judges separately dissented, arguing that the admitting dues as a defense in case of the murder could not be categorically ruled out under the existing international law. Four judges concluded that no specific customary international law rule exists on dues as a defense to killing other human beings. One of the judge, the relevant case law sets down the following test for the defense of the dues. Number one, that the act charge was done under an immediate threat of severe and irreparable harm to the life or limb. Number two, there was no adequate means of averting such evil. Number three, the crime committed was not disproportionate to the evil threatened. In other words, in order not to be disappointed or disproportionate, the crime committed under duress must be on balance the lesser of two evils. The situation leading to the duress must not be have been voluntarily brought about by the person coerced. So there are clear links between this test, Article 31, Paragraph 1, Clause D of the ICC Statute, which also breaks down into a four-part test requiring. So these are the elements requiring the duress and necessity. The existence of the imminent threat beyond the control of the accused. The threat caused the accused to adopt a particular course of conduct. In that course of conduct, the accused acted necessarily and reasonably to avert the threat, and accused intended no greater harm than what which they sought to avoid. In many respects, it may be helpful to read the two together. On the first point, since threat or immediate death or continuing or immediate serious bodily harm must exist, any lesser threat render the defense of inapplicable. So, in this regard, what will be the military duress or necessity? Despite the similarity in terminology, military necessity is a distinct doctrine from the concept of the necessity, which may form part of the defense of the duress. Military necessity may be a defense to certain specified crimes relating to the conduct of the hostilities. It is not a general defense. It originated in a balance between the military and humanitarian interest, which is enshrined at the heart of the international humanitarian law, which must combine pragmatism with the principle in order to be relied upon by the states at all. Two key early authorities on the nature of the imperative military reasons, a concept either the same as or analogous to military necessity, are listed in the Hostages case and von Lewinsky, called von Monstein case. The military necessity has been discussed. The same principle is considered to be expressed in the appeal chamber's earlier judgment in the Cardiff. As a result, it is likely that military necessity is not a defense to the targeting of civilian and civilian objects, at least before the ad hoc tribunal. So, in this regard, there's a principle to Kyoki and reprisals. The two Kyoki principle, literally, you also meaning I can retaliate with your own means of the attack, is one of the most elementary defenses. It seeks to justify conduct on the basis that the adversary was behaving in a similar fashion, sometimes with the strong implications that the advisory started at the two QQ defense however, is no longer accepted in modern international humanitarian law as a defense. This has been confirmed in the jurisprudence of the ad hoc tribunals. These were the defenses and their types which we have discussed. So now after the short break, we will continue, and I will continue this lecture, and there will be the last topic of our this course, that will be immunity. What are the immunities has been provided to the head of states and diplomats?